It is inconceivable that a police officer of the rank of inspector would sit quiet even on hearing threats from a police official of as low a rank as a constable. Stop. If such incidents as alleged by the accused actually happened, they amounted to serious misconduct, even penal offences on the part, amongst others, of Constable Mool Chand. Stop. There was nothing stopping the accused from initiating action against him under the law or through the department by way of reports to his superiors. Stop. There is nothing on record to indicate any such initiative on the part of the accused. Stop. Noticeably, the accused has himself not entered the witness box to vouchsafe the acts pertaining to alleged threats received by him on 25/10/94 and 29/10/94. Stop. The mere reference to the case diaries through DW1 cannot result in the contents thereof being held even remotely being proved. Stop. The fact that accused avoided entering the witness box to depose to such effect rather shows he would not take the risk of facing inconvenient questions in the nature mentioned above, rendering the defense plea further suspect. Stop. I am of the considered opinion that the theory of threats by the complainant side has been invented on the basis of record that has been fabricated. Stanza. A reading of the findings of the court below on the aspect of case diary would clearly indicate an erroneous approach on the part of the trial court in shifting the onus of proof from prosecution to the accused. Stop. I am of the view that the learned court below ought to have considered the facts of the case in its entirety while adverting to the controversy as to whether or not the appellant was guilty of committing the offences complained of. Stanza. It is true that under section 105 of the Evidence Act, the onus of proving exceptions mentioned in the Indian Penal Code lies on the accused, but this section does not at all indicate the nature and standard of proof required. Stop. The Evidence Act does not contemplate that the accused should prove his case with the same strictness and rigor as the prosecution is required to prove a criminal charge. Stop. In fact, from the cardinal principles referred to above, it follows that it is sufficient if the accused is able to prove his case by the standard of preponderance of probabilities as envisaged by section 5 of the Evidence Act, as a result of which he succeeds not because he proves his case